This is Jay Sekulow with analysis of the Supreme Court arguments on the Biden mandate.
Keeping you informed and engaged, now more than ever. This is Sekulow. We want to hear from you. Share and post your comments or call 1-800-684-3110. And now your host, Jordan Sekulow.
Well, this is actually Jay Sekulow here, and we're doing this remote because we've had some weather at our headquarters for our media center. So welcome to the broadcast, everyone. We're going to give you an analysis of what is still going on right now, which is the oral arguments if you're hearing us live at the Supreme Court of the United States regarding the vaccine mandate issue. Now, it was interesting that what is up at play here, and I want to be clear, technically, most of this law goes into effect on Monday. So there were applications for stays filed, which means an application to ask the court to not put the law into effect until a decision is made on the constitutionality of the mandate. We have challenged the mandate not based on science, because I am, as you know, an advocate of vaccines. But everybody makes their own decisions. But I am clearly an advocate of vaccines. I've said that. I continue to believe that. And that's the position that I personally have. But legally speaking, that is constitutionally speaking, I think that the OSHA, the agency that's been tasked with this, does not have that authority constitutionally or statutorily. Now, interestingly, in the beginning of the case, none of that was argued, and we were very, very concerned on how it started. And, of course, obviously, we don't have any decision. But the law goes into effect on Monday unless there's a stay, and it goes into effect in phases. The vaccine records are, if you've been vaccinated, you've got to send those to your employers. I've already done that here. Our other organizations we work with and affiliated have started that process already as well. And then masks for those that are not vaccinated goes into effect. This is according to the government, which is the first time we've heard it, by the way, this way, on Monday, and then testing in early February. Now, having said all of that, in the beginning of this argument, it looked very bleak for the position that there was no statutory authority. And that's mostly because it really wasn't being argued. So I'm going to go quickly here, depending on the time we have, to Andy and Andy first. Andy, never predict by an oral argument, especially an oral argument that is still going on as we're live.
That's absolutely right. You never can predict from an oral argument what the court is going to do. You can never predict what a jury is going to do, for that matter. But in the Supreme Court of the United States, the arguments continue, and you cannot predict what. At first, I thought we would not get a stay. Then as time went on, and the justices began arguing our case for us in many respects, I began to see light at the end of the tunnel and thought that there would be, and perhaps think that there will be, a brief administrative stay based on the arguing, based on the questions that were put to the Solicitor General by the justices, especially Justice Alito and Justice Roberts.
Yeah, I don't know if we have, we do have that actual question. Do we have time, Will, to run it? Because we're doing this remote here, folks. I don't have a time queue. Do we have time to run that? Okay, let's play. This is actually that issue that Andy just raised. This is the question about whether a stay should be issued, which is what we've been arguing.
This ETS was issued a couple of months ago, isn't that right?
On November 5th, that's correct.
Yeah, on November 5th, all right, and it hasn't been enforced during that period. These cases arrived at this court just a short time ago. They present lots of difficult, complicated issues. We have hundreds of pages of briefing. We're receiving very helpful arguments this morning. Does the federal government object to our taking a couple of days, maybe, to think about this, to digest the arguments before people start losing jobs?
Well, Justice Alito, if you're asking whether it would be appropriate for the court to issue a brief administrative stay, certainly we think that that would be within the court's prerogative if it thinks that it's necessary to do that. Ultimately, for the injunction that they're actually asking for here, the applicants would have to show an indisputably clear right to relief, which we think they can't satisfy.
All right, and we will be back in just a few minutes. This is Logan Sekulow, by the way, and we are taking your calls at 1-800-684-3110. That's 1-800-684-3110. I did also want to be clear. Some of you are asking, why are we remote? Well, if you could look outside right now, you know that we got about 6 inches of snow, and we can't get into the studio. At least we can't. But we got some amazing crew people who did get in to make sure you get this broadcast. So I want to thank all of them for getting there. All right, we'll be right back with more on Sekulow. Call us 1-800-684-3110.
Does the President of the United States have the authority to mandate the private employers require vaccination or COVID testing of their employees? Well, that question is now before the U.S. Supreme Court.
A group of Republican-led states, along with business associations and religious groups, have challenged these rules, saying Congress never authorized these types of mandates.
The penalties are very, very steep for noncompliance for employers. We're looking at collectively about 100 million U.S. workers that are impacted by this eventual decision.
Sometimes the Supreme Court is deciding on the constitutionality of laws before them. In this case, it's really about the statute. It's really the question of whether the federal government has the authority to impose these rules. The lower courts have been mixed on this.
If this case actually were to move forward, if OSHA can do this, if CMS can do this, there's really no limiting principle. And do we really want a country where an unelected bureaucrat can dictate this, what people put in their bodies, where people can go, what they put on their face?
If a president can pass these kind of kingly orders and expect them to be obeyed, then the Constitution really means nothing right now. I hope the Supreme Court understands that and reimposes a bit of sanity and restrains this president from overstepping his bounds any further.
It was President Biden, might have been Nancy Pelosi or both, that these federal mandates can't be done. They won't stay constitutional. So if you're a litigant in this thing, if you're representing the states, you're going to be quoting the very people that are pushing these mandates as saying they're failures, that they're not constitutional under our system.
I think they're going to rule pretty quickly. January 10th is a looming deadline on the OSHA side. This is such a big case of consequence. I mean, this is one of the most significant cases the Supreme Court has heard in the history of our republic, certainly on administrative law. So with, all the attention, the impact it will have on, again, 100+ million Americans, I think they'll rule pretty quickly.
Hey, welcome to the broadcast, everyone. We are giving you live analysis of the Supreme Court argument that if you are watching us live or listening to us live is going on still right now. It's on the vaccine mandate issue. Now, the way the mandate's set up, you either are vaccinated, which, as I said, everybody in our sets are, or you get tested once a week and have and you wear a mask in the workplace. Now, that goes into effect. The first time we really heard this, the federal government is conceding basically that the testing doesn't go into effect, at least this is what I understand, until February, but that the mask requirement, if you're not vaccinated, goes into effect on Monday, which, obviously anybody that has got over 100 employees has to do. Now, what's interesting here is the argument started out pretty difficult, to be honest. I mean, I did not see a lot of sympathy for our positions. I think I felt a little bit better as it went on, although I think someone just texted me that Justice Kavanaugh basically indicated that they view the COVID virus as almost like a bioweapon, biohazard. So it's going to be very interesting. But remember, this is up on a stay. I want to get Harry Hutchison involved in this, who was instrumental in working on this case with our team. And is also a law professor, of course, and a senior counsel for the ACLJ. Harry, what's kind of your read on it as where we are right now? I mean, obviously, the case is still going on, folks, as we're talking.
Jay, I think the court acted fairly slowly in terms of the oral argument in clarifying what the mandate actually means. But once they took, for lack of a better term, affirmative action and were engaged, they made several things clear. First, it is clear that the mandate at issue, if not stayed by the court, does not require any testing by employees before February 9th. Second, the mandate allows for a religious exemption, and any application of this mandate to employees must allow for a religious exemption or face particular penalties for acting outside of the mandate. Third, the court doubts that the federal government has broad, unlimited police power to issue a countrywide mandate. Therefore, there is support by at least 3, maybe 4 justices for the proposition that the mandate exceeds the scope of OSHA's power.
Yeah.
And fourth, and quite importantly, the court admits that the vaccine poses a risk to individuals, and therefore this mandate imposes some risk on employees, and therefore the vaccine mandate should be weighed by each individual employee as opposed to some bureaucrat in Washington, D.C.
Now, of course, the question is 4 votes is great, but 5 carries a case. And the way I understand the mandate now, and Harry and Andy, so I think, Andy, we got to be clear here. Everybody was under the impression that everything went into effect Monday. Then the Solicitor General of the United States got up and said, no, wait a minute. And this is why I think she's trying to defeat a stay, frankly. She said, no, the vaccine card acquisition from your staff has to be done before now, but that's an administrative function that everybody could do. We're doing it. Everybody can do it. And a lot of affiliated entities with us are doing it too. Then everybody was under the impression that the testing and the mask requirement if you're unvaccinated was to go into effect Monday too, but no penalties until February for that compliance. But it went into effect. Good faith attempt. She seemed to modify that, as I played earlier, in saying that no, it goes into effect in February. We haven't played that yet. We'll find that one. But so it's still a bit confusing. The problem is, and Harry, I don't disagree with what you're saying, except it takes 5 votes to carry the issue. And I think the mistake that continued to be made here is arguing the efficacy of the vaccine, because I think it's beyond dispute that, in fact, if you're vaccinated, you're less likely to be seriously ill. And that is beyond dispute. It does not answer the legal question, however, as to whether OSHA had the authority. This is what we went back to, Andy, is a question of administrative authority that is lacking here.
Jay, I wish we had made those who are arguing on behalf of the employers and the states would have made that clearer instead of getting into the science and into the medicine. I wish that they would have made clearer early on, like some of the justices did only in questioning of the Solicitor General, that we are arguing a legal position here, and that is that the federal government has no role in this under the Constitution of the United States. The central government is a government of delegated, that is limited powers, and the remaining powers vest with the states under the 10th Amendment. Now, that is an argument that I did not hear with the clarity I would have wanted to hear come out of the petitioners, that is, the employers and the states, in the early part of the argument. I've heard every bit of the argument from the very beginning when the case was called through to the time we went on air. And I wish I had heard that argument.
I need to say it is still being argued right now. I mean, so maybe they are addressing it, but it's being argued right now still.
Yeah, and that could come up.
Let me say this. I want to play, this is for those of you that are employers. We're trying to be really practical here. For employers, this is what the Department of Justice, the Solicitor General's office, has now said as to the effective date of the various aspects of this mandate. I think this will be helpful for employers and employees. So here's what, listen to this was focusing on questions about why it's taken so long to get action. Take a listen.
We think that there are lives being lost every day.
Well, brief compared to what? The months that it hasn't been in effect since November, whatever it is, when the courts have been active in this area, or brief compared to what?
Well, Mr. Chief Justice, I think that the agency well explained that the employers who are covered by this needed time to come into compliance. The agency announced that it was exercising enforcement discretion because of the confusion that had been created by the Fifth Circuit stay. Maybe it would be helpful for me to explain exactly what the January 10th deadline means with respect to compliance. The agency has announced that for employers who are acting in good faith, it is not going to enforce any of the provisions of this ETS until January 10th. And what that means as a practical matter is that employers need to be adopting their policies. They need to be ascertaining the vaccination status of their employees. And as of January 10th, they need to be requiring masking for any employees who remain unvaccinated. So it's not as though immediately employees are going to be quitting their jobs or leaving in response with the worst predictions. On January 10th, if this standard remains in effect, then masking will immediately be required and the testing will kick in on February 9th.
So the way I understand it now is if you're vaccinated, get your vaccine information into your employer. If you're over 100 employees, your employer should set up, they probably set up some kind of portal as we did. You get that. If you're not vaccinated, you're going to have to wear a mask in the office space. But the testing requirement, according to the Solicitor General, doesn't go into effect now until February 9th. Logan, we've got a call. Let's go ahead and try to take a call before we go to break here.
Sure. Let's go to Donna on line 1, who's calling from Washington. Donna, welcome. You're on the air.
Hey, Donna.
Hi, thanks for taking my call.
Sure.
I'll try to be brief. It's kind of confusing to me.
You have to be brief because I only got 3 minutes, so go ahead.
Okay, I will. I'm currently on a medical leave. I work for a large telecommunications company who has indicated that by February 1st, everybody who works in the office must be vaccinated. I've been working from home for a year. There has been no timeline that I need to go back into the office, but apparently because I'm temporary work at home, I have to be vaccinated even though I'm not going into the office. Will this day have anything to do with that?
Not really, because your individual employer could still put requirements in different than what OSHA is mandating. In other words, an individual private employer could still say, we're going to require vaccinations of our employees. Usually it requires some kind of nexus to the workplace. Now, if your job was permanently at home, that might be different. But if you're going to go into that office, they have the right to do that. In fact, they have the right I don't want you to confuse what a private company can do to what the government is trying to do here. And they're two different things. Private employers, and some private employers have said, we're going to have a vaccine mandate in place, period. And private employers can do that. There's religious exemptions, so there's those kind of things. But the mandate isn't that. And I think that's what is the critical aspect of this here. If you see me looking up, it's because I'm looking at the argument that's going on still on these cases right now as we're live. But again, I think, Harry, we only have 1 minute and 30 seconds left, so give me a 45-second. I get a feeling we may get at least a temporary reprieve in an administrative stay sometime this afternoon. Again, it's tough to judge by oral arguments. I've done enough of them to know that, but what's your sense of it?
I agree with you, Jay. I think it's very that you'll get a stay of 48 to 72 hours.
Yeah, I think it's going to be short. Having said that, the good thing about that for employers and for employees, that gives us a time to figure out if what the Solicitor General said is actually the federal government policy, which gives you a little bit more room to implement this. Look, there's a general duty of care to your employees in the workplace. People know that. We put in a filtration system to protect our employees. We've done social distancing. We're doing everything we can. But again, the Supreme Court arguments are ongoing. We're going to continue to give you analysis. We'll take your calls. Logan will tell you what to do if you want to be on air.
Yep, give us a call right now if you have your thoughts or opinions. If you've been listening to the case, maybe like a lot of us have this morning, we'd love to hear from you. 1-800-684-3110. Check out all the great content on ACLJ at aclj.org. If you're watching on social media, make sure you are sharing this with all of your friends. Subscribe on YouTube. We'll be right back.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in application 21A-244, National Federation of Independent Business versus the Department of Labor, and the consolidated case. Mr. Keller?
OSHA's economy-wide one-size-fits-all mandate covering 84 million Americans is not a necessary, indispensable use of OSHA's extraordinary emergency power, which this court has recognized is narrowly circumscribed. Just 3 days ago, the U.S. Postal Service told OSHA that this ETS's requirements are so burdensome for employers that the federal government is now seeking an exemption from its own mandate for the Postal Service. That's because OSHA's economy-wide mandate would cause permanent worker displacement rippling through our national economy, which is already experiencing labor shortages and fragile supply lines. OSHA has never before mandated vaccines or widespread testing, much less across all industries. Our nation's businesses have distributed and administered hundreds of millions of COVID vaccines to Americans. Businesses have encouraged and incentivized their employees to get vaccines. But a single federal agency tasked with occupational standards cannot commandeer businesses economy-wide into becoming de facto public health agencies. So this court should immediately stay OSHA's unprecedented ETS before Monday, when OSHA begins enforcement.
Welcome back to Sekulow. We are taking your calls at 1-800-684-3110. We are doing this show remotely today. If you're curious about maybe the quality difference or you're watching online, that is because we have had a pretty massive snowstorm, and we have a few select crew members who are able to make it in. I want to thank them for getting in and doing it, because without them, we'd be able to do the show. But we knew this show was going to be very important as the case is ongoing in the Supreme Court. A lot of us were listening this morning. Now, one of the things I wanted to bring up with you, Dad, before we even talk about this, is there at least was a moment brought up, which I think a lot of us as employers were concerned about with the testing requirement, is that right now getting tests is not easy, whether you're looking at the at-home test, trying to find them, or even the hours and hours of lines. And that was brought up, and it was sort of shrugged off of, yeah, we kind of did the analysis, and we think that's fine. But is that maybe why now it looks like testing may be pushed until February?
Look, I told you in our brief and in the way I wanted to present the argument in the case, I would have gotten up there and this is what I would have said. And I think it's what Justice Alito said. We're not in any way degrading the effectiveness of vaccines. I'm an advocate, and that's, you could start that way, so you kind of get that out of the way as number one. Number two, the fact of the matter is the world has changed since this ETS, emergency temporary order standards came into effect, because now the exemption, if it's either vaccine or testing in a mask, getting tests are very difficult, and the way the test has to be administered is not easy either. So what you have is a situation where it's almost like legal impossibility. And I think what you saw in that, and that's probably why the Solicitor General, wisely I think, conceded that they will not put the testing aspect of it in place until February 9th, although the masking is going into effect in January. That's not what the statute says, or the rule says, the emergency order says, but that's how they're interpreting it. So it's, to say it's clear, it's not. It's far from clear, but I think at least it gives you a sense of where this could go, where it is going, and how to interpret it, because it is very difficult for the workplace. It's very difficult for the employer and frankly, the employee here. Andy, I was going to ask you this one, and then we'll take some calls. I want to play some sound. It seems like that concession of the implementation of the order or of the regulation, the standard, they were kind of, I think that I can't read the mind of the Solicitor General, but it seems to me that she said that because they know how difficult it really is to comply.
Well, I think that's true, and I think the justices pushed her into a corner when they made her actually admit that there are complications in this rule and in this mandate, or whatever you want to call it, that need to be sorted out. And before you can do that, you start penalizing people. That's not fair. And so she made a concession, which I think was a major concession that had not been made up to this point, and that is masks on Monday, but testing and penalties not till February the 9th. Now, that is something that we had not heard from OSHA until this very morning, and that concession in judicio in the court by the Solicitor General becomes de facto the position of OSHA, and they're stuck with it now, and the justices have heard that, and they're going to make a decision on to whether grant this administrative stay based upon that representation made to them by the Solicitor General of the United States, Jay.
Yeah, so the interesting part of that is,
that they could just say whatever in this case, and it essentially becomes the law, because we've been trying to implement all these policies. So they threw out something new, and that just shifts it to where, well, they threw something out new. De facto, it changes their entire policy. That seems crazy. That's where people, I think, get very frustrated with this, is because ideas can get just thrown out there, and all of a sudden, everything that we just told our employees we had to do, even though we don't necessarily want to, we told we had to do, now gets shifted because someone in a Supreme Court case just offhandedly says, oh, no, we've changed our mind.
Well, that's right, but Andy's correct. The Solicitor General binds the agency. They are the agency's lawyer. The Department of Justice represents OSHA, and they bind the agency. So the agency's now position, their new regulation is no testing, according to what they said at the Supreme Court, until February 9th. Now, what's interesting about that is, does that defeat the need for an administrative stay? I would argue it doesn't, because there's still all other aspects of compliance. But that's why I think that the Department of Justice came up with that position. I thought it was actually a pretty swift move, frankly. And, you know, that's what lawyers do when you're up there. Listen, I always say when you're up there bobbing and weaving, if you were a boxer, that's a boxing analogy. When you're up there bobbing and weaving and, you know, you got to be thinking about all these things while this case is going on. And I think that was their idea of maybe we can defeat the administrative stay. It doesn't affect the long-term stay so much. That'll come with a decision in probably weeks, but we'll see. I mean, we may know something. If the stay's not issued today or tomorrow, it's not a very good sign.
We had a comment come in from Cordell on Facebook, and they asked about specifically the Heritage suit that we were a part of, and they're curious if this is a part of that, and how do they choose who gets to argue what? Why aren't we up there doing that right now?
Okay, so that's good. Our case, actually, we represent the Heritage Foundation. That case has been accepted by the Supreme Court as part of all of this. But you're only seeing, what you're seeing is 2 hours of oral argument for basically 4 cases, and really more like 12 cases. The oral arguments are very small, not insignificant, but a small part of the briefing that goes into this is where the real meat of the work is. Our briefs were filed, accepted, reviewed, are part of the record. It's part of the case. We have a case. What happens? So the oral argument was basically by the government. So that's the Solicitor General's office representing the United States, and then the state of Ohio, and then one of the lawyers representing the National Independent Business Federation. So that's how that was set up. But our case, it will be directly impacted by all of this, obviously, and that's why getting the case up there was such a big deal. It's complicated. You're seeing it play out. I mean, it's complicated to comply. It's a complicated situation, and the atmospherics aren't great right now. We all know that. That's just the reality of the situation. So do we have time to play this bite, Will? I'm probably not. We only got 2 minutes left. Let me go back to Harry here for a moment. Assume we get Harry, one of the things I'm thinking about is she conceded that an administrative stay might be appropriate and then said that the testing doesn't go into effect until February, trying to kind of defeat her own administrative stay. But like you said, administrative stay gets you, what, a couple of days?
Yeah, I think it probably gets you a maximum of 3 days. I doubt it would go longer than that. But I would also concede that the court has to look at tons and tons of briefing. I would also say that the counsel for the National Independent Business Association or Federation did not do a good job on the constitutional issues at stake and the federalism issue at stake. And so I think initially my assessment was this argument against the vaccine mandate was going to go down in flames.
Yeah. You know, it's interesting. I try to not criticize lawyers when they're arguing the case, because unless you've been there and done it, it's very easy to criticize. But when you're up there having to do it, it's tough. And look, he had an argument. You don't also know what the clients were requesting here. So I'm not trying to defend it. I'm just trying to say it's when you're the advocate up there, it's difficult. I would have argued it differently, no question. But everybody's got their own technique, style, and legal. Now, I think it got a little bit better towards the end, but we'll see. All right, we've got another half hour, Logan, coming up.
That's right. If you don't get us on your local station, join us live right now on Facebook and on YouTube and at ACLJ.org. We are broadcasting live on all those outlets. And make sure if you are watching that to share, like, comment, and check out our great work at ACLJ.org. You can catch the show later on as well as a podcast feed on ACLJ.org and the ACLJ app. We'll be right back.
keeping you informed and engaged. Now more than ever. This is Sekulow. And now your host, Jay Sekulow.
I feel like a sportscaster that's calling a play-by-play because the reality is the Supreme Court argument that we're talking about is still going on while we're live. So, I mean, we're just dealing with what we're giving you the best analysis we can. What's up is the mandate, which either requires a vaccine or, in the alternative, a test and and wearing a mask if you're in the workplace. It seemed early on that there was not a lot of support for issuing a stay. That's the way the case started out. There was skepticism by a lot of justices, including Justice Thomas, Justice Alito, Justice Roberts. And then Justice Roberts actually seemed to become the more aggressive on our position, which is the lack of statutory authority to implement it. Now, the government made a huge concession, I think, trying to defeat the need for a stay by saying that while the vaccine issue of if you're vaccinated, you got to provide your vaccine card to your employer, which is not a big issue. You put it up, but that the testing, if you're not vaccinated, actually doesn't go into effect until February, which is the whole thing. If you think about it, the way the situation is now, this thing was done in September, October, and the world has changed a lot, and that's why these things don't work. But the real issue that should have been addressed head on, in my view, was what the president said, was that there was, in fact, no federal solution to this, that it's up to the states, which is the position we've taken. And I'm talking about President Biden there. We actually agree with him on that. He agreed with us. And secondly, that there was a lack of statutory and constitutional authority. They hit the statutory first before they hit the constitutional, because of the lack of statutory authority would avoid the ability of this agency to be the agency that's putting this mandate in place. So having said all of that, I keep looking up at my screen to see if I'm seeing anything that's coming up. My sense right now is that we have a situation, Logan, where we may see a short-term administrative stay. That's possible. And we may not. And we don't think that now the testing is required until February 9th. So we may see everybody may be modifying their positions based on that. You asked a great question, which is, can a government lawyer bind an agency? And the answer is yes.
Yeah, that's pretty crazy, I think, for a lot of people to hear that just those simple changes can really throw everything, into effect. Now, we had that situation when you watch this case where it did seem like the government lawyers were conceding a little bit. They were conceding, yeah, maybe you could do a stay. Maybe you could do, delay. It seems like they gave themselves wiggle room in this, knowing that the testing situation is what it is. And maybe we're the other side, but didn't give as much. Was that an interesting play, do you think?
Yeah, I think the Solicitor General actually was smart in saying that administrative stay could be appropriate on a limited basis. I think she was smart in saying that the testing mandate won't go into effect until February. That means the court could issue a full opinion on that, because if you're already vaccinated, the only thing you have to do is show your card, and that's it. Yeah. So I think
way less extreme.
It sure did. I think that, but look, that's good lawyering. Whether you agree with the position or not, it's good lawyering. I think the problem with some of the positions that were being advocated, at least early on, in my view, it was scaring the court, because there was this statement that this is grave danger and grave concern, but OSHA can't do anything, and that sounds really extreme. Instead of getting up and saying, lack of statutory authority, the mandate can't even be put in effect, we could have taken that away. But again, I am not going to criticize the lawyers that are presenting the case, because they're the ones up there, and people have done that to me. They've criticized me when I've won cases 9-0. They're not so critical when you win 9-0, right, but they are during the argument. So I'm not gonna blame the lawyers. They had clients. You don't know what the state of Ohio had, I'm sure, requirements they wanted, issues they wanted left. So those are normal kind of things that you have in place. But having said all of that, we're still, you see me looking down or looking up, as we're still analyzing this as we're calling it live as it's happening, and giving the best analysis. We'll take your phone calls when we come back as well, Logan, because people do have questions on this.
That's right. We are going to take some phone calls, 1-800-684-3110. Some lines are open right now. We do have some calls already ready to go. We'll get to those in the next few segments. 1-800-684-3110. We'll also have a special guest join us later in the show as well. But again, 1-800-684-3110 to have your voice heard on this critical issue right now. And always support the work of the ACLJ. Go to aclj.org. Look at the amazing work that we're doing and the great content we're producing.
May it please the court. OSHA typically identifies a workplace danger and then regulates it. But here, the president decided to regulate a danger and then told OSHA to find a work-related basis for doing so. This resulted in the vaccine mandate, a blunderbuss rule nationwide in scope that requires the same thing of all covered employers, regardless of the other steps they've taken to protect employees, regardless of the nature of their workplaces, regardless of their employees' risk factors, and regardless of local conditions, state and local officials are far better positioned to understand and accommodate. So sweeping a rule is not necessary to protect employees from a grave danger as the emergency provision requires. And I want to be clear, the states share OSHA's desire to bring this pandemic to a close, but the agency cannot pursue that laudable goal unlawfully. I welcome your questions.
Are you asking us both still to issue a stay today, tomorrow, Monday? And why?
Thank you for the question. We are seeking an immediate stay. Congress told us who decides. The 28 U.S.C. 2112 says that courts can issue stays. And the reason for that is they recognize that this was without notice and comment. And unless the courts could step in to abate illegal actions, nobody would be able to do so. And that's especially important here, where the action they're, in our view, mandating, but at least strongly encouraging vaccination cannot be undone. Finally, the other point in the public interest is that one awkwardness of this situation is that the ETS is focused on what was really a different pandemic. It's all about the Delta variant. Now we are on to Omicron, and as my presence here as a triple vaccinated individual by phone suggests, and as Justice Sotomayor suggested, and as the amicus brief from the American Commitment Foundation shows, vaccines do not appear to be very effective in stopping the spread or transmission. They are very effective in stopping severe consequences, and that's why our states strongly urge people to get them. But I think that makes it very hard to look at the numbers they give and assume that they still apply today.
This is Logan Sekulow. We're going to go jump right to the calls. Our phone lines are completely jammed, but keep calling 1-800-684-3110. And Mike Pompeo will be joining us in the final segment of the show to wrap us up. But let's go to Rena, who's calling on line 1 from California. Rena, you're on the air.
Hi, guys. Hi, Jade. Listen, I want to know if the justices violate the Constitution and allow this illegal federal mandate to stand, what is we the people's recourse to protect ourselves legally against them doing that?
Well, first of all, if the Supreme Court justices say that it's not unconstitutional, if the mandate's not unconstitutional, then the law of the land, I want to be clear on this, is it's not unconstitutional. So you could disagree with it. You could think the Supreme Court got it wrong, but that does not equate to a situation where you can then go violate the law. You do that at your own peril, including serious penalties and fines in this particular case. So the law will be determined by the Supreme Court here if they address the merits. It's a temporary order. So, Andy, one of the things I thought about, so by the way, once they make the decision, that's it. I mean, there is no, now they could, but there's 15 different ways this could go. They could make a temporary decision, send it back to the Sixth Circuit. I mean, so we're not going to know anything, Andy, here definitive until we get the decision from the court. But what we do know definitive is if the court were to say that the mandate is in fact constitutional, well, that's the law.
That's it. That's why it's called the Supreme Court of the United States. It's the court of last resort. And if the Supreme Court of the United States says that the mandate is constitutional, so be it. That ends it. You follow the law. You do what the law says until and unless the Supreme Court decides, if they ever do, to reverse themselves. But you don't go violating the law. So you have no alternative. That's why it's called, as I said, the Supreme Court of the United States.
But Harry, there's another aspect of this.
Would your other alternative be to just find an employer that's, it's hard, easier said than done, has less than 100 employees and is not going to be following this? I mean, it's sadly to say the case, but maybe that's your only theoretical option.
Except a private employer with less than 100 employees could still impose a mandate themselves. This is just whether the government can do it. A private employer certainly can put these in place, subject to religious freedom and freedom of conscience issues. But I mean, generally, those would be difficult in a case like this. So a private employer certainly could do it. I mean, the question here, I guess, Harry, is, and that's a good one, Logan, too, is there's so many different ways the Supreme Court could go, and especially in light of the Solicitor General's intentional, I would say, concession about the application of the testing requirement, that it really could go a lot of different ways here. It's very hard to predict.
I think you're absolutely correct. And essentially, the government has admitted that this mandate, for practical purposes, does not really go into effect, presumably, until the 9th of February. So in some respects, the government is asking for, not directly, of course, an administrative stay till that particular date, or basically saying, okay, we are not going to go after employers. The second point, of course, is that in order for OSHA to go after employers, based on my understanding of the law, and there's some disagreement on this, they may need cooperation from state OSHA departments. I don't know if that's clearly the case.
Last night, and that's going to depend on this. The various states have different rules on that. So there's like 21 states, I think, that have state OSHAs that implicate on these issues. There are, 28 states that do not, or something like. I mean, there's 50 states. So I don't know what, but it was like 21 or 22 that did. So that's where you're right. It could get very confusing, except if they don't issue a stay, at which point the Supreme Court has basically let the law go into effect. Which I think there's 4 justices that would clearly do that. Logan, let's go take a call.
Sorry, let's go to Ben from North Dakota on line 2. Ben, you're on the air.
Hi,
Ben.
thanks for taking my call. I just have a quick, simple question. Are employees legally obligated to provide vaccination status to their employers?
Well, your employer, if a private employer could, number one, require it, and they have the right to do that, if you're vaccinated, to ask for your card as proof, and then have that for OSHA. Private employers could mandate that themselves. Private employers have, other employers don't. So this issue is whether OSHA, whether a federal agency has the authority to do this, and that's what's being really debated right now.
Yep, we had another call that came in. They just dropped, but I think we should get that question answered. And that was from Doug in Texas. Doug, sorry about that. He said he understands that all the cases are consolidated, but will the ACLJ's filing be specifically considered by the Supreme Court of the United States, and how does that work?
Yeah, so all the briefs, everything has been consolidated. There's multiple orders, but yes, all of our briefs were accepted, filed, read. That's how the courts do it, and the clerks go through these in great detail. And the opinion in these 2 cases will be the opinion in all of the cases. So all you're seeing today, and it's a great question, is just the oral argument portion. There are hundreds, thousands of pages of briefs that have been filed in this case literally within a couple of weeks. Thousands of pages between both sides. So that's all there.
What about an update on how long you think this will take until we have at least some kind of decision? I know people are expecting the potential. If we know there'll be a stay, do you think we'll know relatively quickly? And then when does the decision? Because a lot of times people think the Supreme Court, they think of these arguments happen, and then 6 months later we get a decision.
Okay, so here's the thing. I think if we're going to get an administrative stay, we get it today or tomorrow, Sunday at the latest. If we don't get an administrative stay by the weekend, I think it's not a great sign. Andy, what do you think?
I agree with you. I think if there's going to be an administrative stay granted in the case, it's going to be granted after the conference this afternoon. It could be as late as anytime tonight. The court issues orders 24/7. It could be tomorrow. It could be Sunday. I think if we get a stay, it will, however, come before Monday when the mask mandate would go into effect.
The new mask mandate, I would say, because they changed their policy on that. Go ahead, Logan.
All right, let's go to Dan on line 4. Dan, you're on the air.
Hey, guys, big fans. Thank you so much for holding me. Tune in all the time. Been trying to get to you and ask this question for a while. I don't see how anything EUA, mass testing, or these vaccines could be mandated. I thought case law was clear in Doe versus Rumsfeld that nothing EUA could be mandated. There is no Comirnaty that's not being produced. The Fifth Circuit already definitively found that it's not available. It's not being administered.
But here's what happened. The Fifth Circuit case was then all the cases were consolidated to the Sixth Circuit under the multi-jurisdiction statute. What that means is the Fifth Circuit decision was basically left in place until the Sixth Circuit ruled for the rest of the country. And they did. And they held that the mandate, in fact, was constitutional. That included a Republican appointee to the Sixth Circuit Court of Appeals. Then what happened was the cases went to the Supreme Court of the United States. We requested, along with everybody else, an administrative stay pending the disposition. We didn't get it. They didn't issue a stay. The opinion stayed in effect. The opinion of the Sixth Circuit right now is in effect, which has the mandate going into effect with the now modified issue of that the testing requirement will not take place until February. I know this is technical, but we got a lot of employees and a lot of employers that are listening to the broadcast. I'm trying to be as clear as I can. That effectively, Logan, as you asked, did modify that rule. They can bind
but
the
also,
agency.
as one of our producers just put in, also said the FDA has also approved these vaccines now, so it's no longer just emergency use authorization for at least the initial doses.
No, that's correct. I mean, so
all right,
that really didn't come up much of that was not a big part of the argument today.
Yep. Hey, do we have any other calls, or is that it? Our producers can tell us. All right, I assume that we're good, right? We're still screening calls. We'll take as many as we can, but right now we are starting to wrap up the show for calls. But in the next segment, we're going to be joined by Mike Pompeo, who will be joining us to discuss all these issues and talk about the great content. By the way, if you haven't read his content that he puts on ACLJ.org every week, I encourage you all to go to ACLJ.org and read some of the great content that is there and see the great videos and the series and all the great stuff we put out. Yeah, this is just if you watch the 1 hour a day, it's just a small portion. It's kind of like the oral argument. It's just a small portion of the overall scope of what we do as an organization and the content that we produce.
Yep. You know what? I want to thank our team that came in through very treacherous roadways, and they got in safely, which we said if you can't get in safe, don't go. But they did, and that's why we're all in different locations. Literally, all four of us are someplace else. Because of the technology we have, we're able to do this both on Facebook, YouTube, whatever, Rumble, whatever you're watching us on right now, and also on our radio stations around the country because of your support for the ACLJ. So I want to say a huge thank you to our team. I want to put this back in perspective. What is being asked? What's up is the court is an application for a long-term stay and a short-term stay. An administrative stay so that this doesn't go into effect Monday, a longer-term stay so that the case can be considered. The Department of Justice Solicitor General, who binds the agency here, said that the masking requirement will go into effect Monday, but the testing requirement will not. That was a change from previous OSHA positions as early as late as yesterday. So they modified their position somewhat. Where the justices come out on this, look, oral arguments are, like Logan said, a small slice of the overall aspect of the case. So we'll see. We're going to see. We're going to know, I think, very soon. Mike Pompeo is joining us in just a few moments. We'll take his comments. It'll be very interesting to hear what he has to say. Back with more in a few minutes.
Question on this issue of the commencement of enforcement and the issuance of a stay. This ETS was issued a couple of months ago, isn't that right?
On November 5th, that's correct.
Yeah, November 5th, all right, and it hasn't been enforced during that period. These cases arrived at this court just a short time ago. They present lots of difficult, complicated issues. We have hundreds of pages of briefing. We're receiving very helpful arguments this morning. Does the federal government object to our taking a couple of days, maybe, to think about this, to digest the arguments before people start losing jobs?
If you're asking whether it would be appropriate for the court to issue a brief administrative stay, certainly we think that would be within the court's prerogative if it thinks that it's necessary to do that. For the injunction that they're actually asking for here, the applicants would have to show an indisputably clear right to relief, which we think they can't satisfy.
Well, I'm asking about an administrative stay. You think it would be appropriate or it would not be appropriate if we issued a short administrative stay? Or if we do that, are you going to say, well, they're causing people to die every day?
We do think that the agency found that there is grave harm every day, and the numbers are stark. Thousands
but there was
of
that
lives,
grave harm during every single day.
Hospitalizations over
was there not that same grave harm during every single day between the time when this was issued and today?
You think that the harm has existed and been present throughout, and the agency specifically set aggressive compliance deadlines.
Well, my answer, I asked a really simple question, and you have the prerogative to say, no, we think, horrible consequences are going to ensue if you issue even an administrative stay of a short period of time, and we don't think that you need to have that time to digest this case and decide it.
I'm not going to say that, Justice Alito. If the court believes that it needs a brief administrative stay, then of course it can enter it.
Welcome back to Sekulow. To wrap it up, we are joined by Senior Counsel for Global Affairs at the ACLJ, and of course, former Secretary of State Mike Pompeo, who tweeted this yesterday. Tomorrow's arguments, and this was yesterday, obviously, we're talking about what we're talking about. Tomorrow's arguments before the Supreme Court of the United States are critical, and I pray they do what is right and reject President Biden's unconstitutional mandate. So, Secretary Pompeo, thanks for joining us.
Jordan, it's great to be with you.
Hey, Mike, so this is Jay, and I wanted to, I feel like I'm calling, a live baseball game here because we're talking about this while we're live, and it's still, the argument itself is still live. We've taken the position that statutorily and constitutionally, that this was an unconstitutional move, and statutory authority wasn't there to do this. And without getting into the weeds, what was up in the case here was an administrative stay initially, and then a longer-term stay while the court gives the disposition. Give us your sense of the significance of this, because the problem here is not so much, and I've been a big advocate of the vaccines. I've been very clear on that, and I'm proud to say that. Other people have different positions. It's a free country. But here's the thing that I don't understand. I don't understand why the court didn't initially give an administrative stay, and the Solicitor General today changed the effective date of this, at least as to the testing, until February, which was interesting. I think that was to avoid the maybe administrative stay. But what's your sense of the situation?
Yeah, I think, Jay, you've scoped this out pretty well. First principle, this is an OSHA rule, right? I remember when we were trying to do things through administrative processes, they have ultimately failed to execute. So as a purely legal matter, I think this is ultimately going to be found by the Supreme Court not to be permissible or appropriate. I think they're going to strike this down. As for the immediacy of this, you could hear the response from the government under the questions that Justice Alito asked this morning. They know that they sat on this for a long time and now are declaring that this is an emergency in a way that doesn't permit the court the capacity to do this in a reasoned way. I think the courts are going to find that that's the case. On the bigger issue, on the practical import of this, I think you've got this exactly right. These mandates don't function to serve the purpose for which the Biden administration, the Justice Department, has put their legal defense forward. We know that this COVID thing is going to be here for a while. We know that most people are choosing to become vaccinated, and it is keeping them from going to hospitals and keeping them safer. Those are all good things. But the federal government issuing a mandate for such a thing and doing it on pain of loss of the capacity to take care of your family and feed your children and pay your lease and your rent, I think that is an outrageous overreach by the United States government as a policy matter. And I think they'll find it both unlawful and illegal as a legal and constitutional matter as well.
I would have gotten up and I say I don't ever want to criticize the lawyers that are arguing, because I've done this many, many times now and for 4 decades. And so, you're up there bobbing and weaving. It's easy to criticize when you're not the one having to come up with this. But one of the things I said was I would have initially said, first of all, that what President Biden said was correct, that there's not a federal solution here, that the states have to solve this, because the states can deal with it on the state basis where there's issues, and they can even delegate that to the counties. That's number one. Number two, the testing mandate problem is not that the test is so invasive. It's that you can't get the test. So it's the doctrine of legal impossibility. You can't even comply with this. So, I find the whole approach here to be constitutionally awkward, to say the least, and that may be a new phrase, but and constitutionally suspect. But trying to apply this, we were up till, Mike, last night with our HR people trying to figure out what do we do for Monday. This is how complicated this situation is. And you've got employees that can't be vaccinated because of immunocompromisation. And can they get tested in time? These are real situations that people have. And like I said, I'm pro-vax, but the government doing this is just difficult to conceive of how this can roll out smoothly. And of course, that's why the government said, oh, no, we're not going to have testing until February now, which is not actually what the mandate says.
No, that's right. Look, Jay, this is not an academic exercise. This is a real exercise where real lives are going to be impacted, not only the individuals' lives and their families' lives, but the lives of businesses trying to figure out how to get enough pilots to fly airplanes, and for companies like yours, businesses like yours, organizations like the ACLJ to continue to perform their important missions. This was put together hastily in an attempt to suggest somehow that they were doing something, because I think as a political matter, President Biden claimed he was going to destroy the virus. We can see by the hundreds of thousands of cases every day, he hasn't done that. So he's got a politically difficult bridge. And so they sent OSHA off, the Department of Labor off, to put together rules to do something. And I think now the poor lawyers who are having to defend this can see that the do something theory is he's used constitutionally awkward. I think that's pretty diplomatic and kind. Maybe you can run the State Department one day. I think this is constitutionally a disaster. And from the perspective of our governance model, this would give OSHA the right to do just about anything in the name of safety for the workplace.
I always try to be kind to the lawyers arguing, because I've been in that position wwhere you get the left, the kind of the left hook question, I should say. Justice Stevens, who was a really nice guy, but he would give you, anytime he would say the words "supposing" as part of his hypothetical, you knew you were about to get a left hook. So get your arms up, because you got to block it. Having said that, all right. So we look at this. I think about what happened when you were in office, and Operation Warp Speed, and all of these things moved in a systematic way. And then looking at it now, I hate to get into the politics of this, but it seems like, as I said, the Department of Justice changed the policy while they were up there today.
Yes, and the CDC and the NIH and others are changing their protocols and their guidance
today.
Every day, sometimes multiple times a day. It certainly feels like it's to the whims of public perception of what's taking place. What we need is good science, rational debate, good logic in the presentation of how the federal government messages, and then let these governors, let these county commissioners, let these school boards make good decisions for their own systems, their own states, their own regions, and we'll get to a solution that is workable to deal with this ongoing challenge from COVID much more quickly.
Yeah, I was going to say, Mike, I totally agree on that part. I think that the part of what you saw today unfold, and it's still unfolding as we're live, is that the lack of clarity of the mandate itself has created a really big part of the problem here. Quickly, let me close with this, Mike. We only got about a minute left here. We don't know what the Supreme Court's going to do. Maybe they'll issue a stay, maybe they don't. But the end result of this does show that Supreme Court justices make a big difference.
They do. We can never forget that. The ACLJ has done a wonderful job of highlighting the different positions that different justices taking, talking about why this matters. We all know that these elections for President of the United States and for the United States Senate matter, because those are the folks that choose who our justices are. And if they choose people who are political and aren't prepared to defend the Constitution, then there's real risk to the Republic.
All right, the former Secretary of State Mike Pompeo, the senior counsel to the ACLJ. Thanks for being with us. Appreciate your insight. As I said, we're calling it live as we see it, and I appreciate that. Logan, back to you.
That's right. We got to wrap up this show. Thank you all for calling in, for being part of the broadcast today. Thanks to obviously our crew who was able to safely get in to produce this as we host this show remotely. So I want to thank them and really appreciate all their hard work as we keep this live analysis going. Now, if something big changes, something big happens, we'll do our best to keep you updated. The best way to do that is to make sure you are actively involved with the ACLJ. So go to aclj.org, like this page if you're watching on Facebook, subscribe on YouTube. We'll try to be as current as we can. We're on Instagram. We're everywhere you need to get media. We are there. So make sure you are staying up to date with what is going on in the world by following everything that we do at aclj.org. That's going to do it for today's show. Thank you guys so much for joining us. We'll be back on Monday, hopefully in studio if this snow will melt, and we'll see you then.